You're welcome back. This is The Law. It's your legal light. It's your health law. And we're doing part 2 of the contracts of employment. And my very good friends and brothers have agreed, as they did the last time, and have kept to their word, and they are here. Lantig A. Apanga is managing partner, Prestige Partners, and Charles Baldua is managing partner, Law Alert Group. They are back in the studio. Good afternoon and welcome back to The Law.
Good afternoon, Samson.
Great. So let's go straight to The Law 101. Today, what are we looking at? 2 minutes each for our guests to educate us on a particular aspect of the law, more particularly the Constitution, so that by the time we are done, if you didn't learn anything at all, you ought to have learned this one. So the Law 101. Today, we are looking at Article 24 of the Constitution. It says every person has a right to work under satisfactory, safe, and healthy conditions, and shall receive equal pay for equal work without distinction of any kind. Every worker shall be assured of rest, leisure, and reasonable limitation of working hours and periods of holidays with pay, as well as remuneration for public holidays. Every worker has a right to form or join a trade union of his choice for the promotion and protection of his economic and social interests, and restrictions shall not be placed on the exercise of the right conferred by Clause 3 of this article, except restrictions prescribed by law and reasonably necessary in the interest of national security or public order, or for the protection of the rights and freedoms of others. Let's begin with Charles. What's the significance of this particular provision of the Constitution, Article 24?
Thank you very much, Samson. Let me say that even though you talked of 2 minutes each,
it's a whole book.
Yes, the provisions that you have requested us to enlighten the public on so important and so robust that it will be very, very difficult, if not impossible, to try to, no matter how you summarize, to do that in 2 minutes. So I will try.
Okay.
First of all, these are constitutional provisions. The significance is that they are very, very important provisions in the laws of Ghana, because the Constitution is the supreme law.
All right.
Now, secondly, they fall under the part of the Constitution where we term as fundamental human rights.
Right.
So they are human rights, so fundamental to every citizen of Ghana and to persons living in Ghana.
Right.
And they cannot be whittled away. Right. Now, the provision talks about the right to work. So it's giving every individual resident in Ghana the right to work, and especially under satisfactory conditions. Conditions that will enable the worker to work well and to be paid well. It's not the situation of just giving anything as a pay. It should be well paid and not discriminated against. Because if you pay a particular worker or workers who do the same kind of work, different salaries, you are discriminating. Okay. And that's why the Constitution talks about equal pay for equal work. Then it proceeds to talk about trade unionism, the right of the worker to join or form a trade union.
Right.
This is intended to ensure that the workers get protection, because it's not in doubt that workers get better protection when they are unionized than those who do not. But subclause 4 is a kind of clawback from clause 3, because it talks about restrictions. And what it means is that this rights which has been elaborated can be restricted. But the important thing we must note therein is that The restriction cannot be arbitrary.
All right.
It must be one made by law, one for the public interest, national security, and the rights of others.
Okay.
So these are the bases upon which your right to work, your right to join or form a trade union can be restricted.
And if those laws are not reasonably necessary, they can be impeached in the Supreme Court.
And a clear case where this provision was practicalized was in the case of Adolfo versus Ghana Cocoa Board. The background, very simply, is that somewhere in 1993 to 1995, Cocoa Board decided to retrench some of its workers. So there was an existing PNDC law which allowed Cocoa Board to restructure. It's a PNDC law 125. That law said that the management of Cocoa Board were entitled to send the workers at home on redundancy and to decide how much unilaterally should be paid to them. Meanwhile, these workers had, in exercise of their constitutional right, joined a union and collectively bargained a collective bargaining certificate agreement, which provided for how much they should be paid.
Okay.
This was ignored by the management of Cocoa Board. In the application of PNDC law 125, they went to court, the Supreme Court, to say that to the extent that that PNDC law did not allow them to exercise their constitutional rights of having formed a union and negotiated collectively, it was inconsistent with the Constitution and should be struck out.
Okay.
The Supreme Court considered it and agreed with them particularly. And the court made certain pronouncements. Let me briefly read.
Okay. Because
it talks about the importance of this constitutional provision. The court proceeded to say that by Article 1(2) of the Constitution is the supreme law of Ghana. And any other law found to be inconsistent with any of its provisions is to be held void to the extent of its inconsistency. In accordance with this fundamental constitutional principle, the plaintiffs rely on Article 24(3) and Article 24(4), the very articles that we are talking about, to sustain their argument of unconstitutionality. And the court quoted those provisions and proceeded to say that Clause 3 of Article 24 of the 1992 Constitution does provide for the fundamental right of freedom of association in relation to trade unions, and implicitly for the right to collectively bargain. These two rights are recognized by the International Labour Organization as part of minimum standards for workers' rights. Under Article 2 of the ILO Convention 89, which talks about the right to form trade unions, a trade union is recognized as one of the fundamental rights of workers. Then in 1948, the International Labour Organization adopted a landmark convention. It provided that convention, then concluded as follows: this court should accordingly not lightly allow those rights to be eroded.
Okay.
Although Clause 4 of Article 24 is a clawback provision which permits a derogation from those rights within the limits therein specified. We are saying that quite apart from the express language of Article 24 of the 1992 Constitution, the international labor laws context of this provision imposes a restraint on the extent of any derogation.
Okay.
So in sum, this is not just a law applicable in Ghana. It is of international standard, which requires that it is observed.
Right.
By all of us, and especially employers.
Thank you very much. And that's expansive with sufficient background and even Supreme Court decision to help you appreciate that law. Now, last week, I think that when you look at Clause 2, we spoke a bit about Clause 2, where it talks about the worker, every worker shall be assured of rest, leisure, and reasonable limitations of working hours and periods of holidays with pay, as well as remuneration for public holidays. So, what do you have to say?
Well, Samson, I'll try to simplify it because we have very short time.
That's right.
2 minutes to do this.
That's right. Yeah, we have already exceeded that.
Yes.
Yeah.
I'll simplify it. In fact, the Article 24 has 3 main clauses that needs to be taken care of.
Okay.
The fourth one is only a condition to the other 3. And I'll simplify it by naming it PPC. pay party company.
Pay party company. Okay.
Pay to take care of Article 24.1.
Okay.
That talks about every worker has the right to work in a satisfactory condition and to be paid for equal work, equal pay. 2 talks about leisure, that you have the right to leisure leave and to observe holidays, and where you work on holidays, you should be paid extra.
Yes, and you emphasized last week that your leave period should not be bargained.
You cannot bargain.
In fact, if you sell it off, what you are doing is void.
It's void. It's void. And so, party here to take care of leisure. The law understands that we are human beings. We can't work all throughout. We need time to rest. We need time to recreate. We need time for recreational activities and time to rejuvenate.
Right.
That is why the law, in its own wisdom, provides us with the opportunity to have some rest. And that is why we have public holidays.
Right.
And the law also says that even if you work on public holidays, you are required to be paid extra for having worked on that public holiday.
All right.
So I use the word party to take care of 24.2.
Okay.
And then I'll come to
so
C.
pay, party, and the last P.
C, company.
Okay.
That you have the right to form or join any work association or a group of your kind. So company here is the company you keep, the company of workers that you would want to join.
All right.
That the law does not impose any restriction on you to belong to a particular work group or work association.
Right.
You have the liberty to do so.
Right.
However, 24.4 provides certain conditions to 3. That says that even though you have the liberty to join all these associations out of your choice, as far as it is not injurious to the national security of the country, as far as it does not affect public order and public the interest of the entire nation, then you are free to join.
That's
and
right.
so we'll have to look at it vis-a-vis distance. So simply put, because this is Law 101,
right.
I want them to take home with them something that they can always remember.
Pay,
Party,
and
company.
party is not like an individual or something. It's like, I like the way he puts it, party. Just go have a party. Like the law, constitution actually wants you to have party when you are working.
Yes.
You know, they say all work and no play makes Jack a dull boy. Right, so that's important. So when you work, you play, and then you have the right to the C.
To keep company.
To keep company. Great. Thank you very much. So that has been the Law 101 on Article 24. Let's go straight. Yes, last week we had the second issue sent to us by one of our viewers, and we couldn't deal with. So let's go to that right away. So here is our second issue for our legal clinic. So, Abubakar Sadiq, he says, I am a nurse and my colleagues are pressuring me to join any of the major nursing unions, claiming it is compulsory per our laws, even though I do not want to. Is it compulsory to join such unions? GRNMA and UPNMA. I need education. Back to you, Charles.
Yeah. Well, it's a quite straightforward situation. First of all, we have already talked about trade unionism as provided for in Article 24.3. Prior to that, there is Article 21E, which provides for a right, the workers' right to join a trade union of one's choice.
Okay.
I think the emphasis therein is one's choice. So clearly, you are not under any compulsion to join a trade union in the first place. And you are not also under any compulsion to join any particular trade union. So there's no compulsion. Now, however, I want to advise that it is advisable to join a trade union because the benefits of a trade union are abound. Now, the trade unions actually negotiate collective agreements. They negotiate the conditions under which you work. And so they protect your interests. They protect your work. They protect your employment. So that if you opt out of a trade union, you are less likely capable to fight for the protection of your employment and then, of course, to fight for better remuneration. So it is always advisable to join a trade union. Now, it's not just the question of joining any trade union. You must join a trade union that has a national character, a trade union that has national influence and can influence activities at your workplace, can even influence national life, so that way you are in a stronger group. Now let's take the situation of UTAC, which is currently unfolding.
University Teachers Association.
University Teachers Association. Clearly they are on strike. So because of that, every university has virtually come to a standstill. Assuming people had decided to belong to smaller university teachers associations. If, for example, one university decided, oh, we are not part of UTAC, we want to form our union. Good, the law allows you, because it says join any trade union or form any trade union. But you see, of what impact will that smaller trade union play when it comes to important issues, such as the kind of issue that UTAC is dealing with? But you see, they are able to push their point. They are able to make inroads and to get government to negotiate because they are united. It is a bigger trade union.
Right.
So the practice which has now come about, because where people join enterprise unions rather than national unions, is working to the detriment of the worker, because the enterprise union will have less effect. And let's note that when you have 2 or more unions at a particular workplace, the law says that the union with the highest number of members will be issued with the collective bargaining certificate. So what this means is that even though the smaller unions may be consulted, the actual negotiations and conclusions that will arrive at a document that will govern the employment at the workplace is done by the bigger union.
Okay. But why should I join? Because, and I hear people say it, particularly the teachers. They say, I'm getting deducted for that. I don't like the idea. You have taught us through this process and through taking us through the constitutional provisions. My work and employment is already protected. Why do I need a union for that purpose?
Samson, there are 2 sides to the coin. We have to look at it carefully. You have a right and you have a choice. Your choice, the right that you want to exercise, may come with some obligations. Now, the Constitution provides you the right to join any worker group or association of your choice, and even form one of your choice.
Right.
Likewise, Section 79 of the Labor Act allows you that. These are fundamental rights that you have, and you can choose to exercise those rights. But as we say in law, whatever right you choose to exercise, it may come with some obligation. And so if you decide that you would not want to belong to any association, worker group or association or labor union, you are free to do so. However, you will not benefit from those who belong to the association and the decisions they make for their members that brings them benefits.
If my employer
Yes.
does things for those people,
Yes.
and like you just explained to us through Article 24, he's not supposed to be discriminatory.
Yes.
You are supposed to have equal pay for equal work.
Yes.
If I'm not in a union, I'll still get the same pay. So what's the problem?
Yes, but pay is just one aspect of the things we are looking at.
Okay.
There's something we call disciplinary proceedings. In some work organizations, the collective bargaining agreement defines how disciplinary proceedings should be or conflict should be resolved. Now, you as an individual who don't belong to that association, if you decide to take yourself out, how do you define how you deal with conflict that arises between you and your employer? Particularly when it's not defined in any collective bargaining document. And so that is why it becomes difficult to single yourself out from the group. If you desire to do so, then you may have challenges.
Okay.
The challenges you are going to have is that there must be defined rules and regulations between you and the employer to deal with you, one individual, when in fact the employer can put all of you together and have certain rules and regulations that govern your relationship.
He says, is it compulsory to join a trade union? Your answer unanimously is no.
No.
And yet, by the explanations you're giving and the benefits in a trade union, you are almost making it compulsory.
No, sorry. We are saying in simple. It is not compulsory, but it is advisable.
Okay.
That is a summary of what we are saying. You see, it is true that there are protections provided in the law, but we have said time and again that the law only provides minimums. It provides minimum protection, not maximum. The trade union can negotiate maximum protection. We talked of leave. You are not a member of the trade union. The worker can decide, okay, you are entitled to 15 days leave. I have complied with the law.
That's what the law says.
The trade union can negotiate 30 days leave. Apart from that, when you look at Section 19 of the Act, the Labour Act, and Section 105, it talks about the protection provided in a collective agreement being superior to those in a contract of employment as in an employment letter.
If those are better than
what is in the employment letter.
Okay.
So there's a second tier protection for you. So that when the situation of termination arises, or remuneration how to be computed arises, and what you have in your appointment letter is less favorable to you, the law will go for what is in the collective agreement. If you are not a member of the union, you don't have that automatic option of going for collective agreement. So being a part of a union is very crucial and fundamental. Apart from that, experience has shown that workers who belong to a better union get better benefits than those who are not unionized.
All right. Okay, thank you very much. You were talking about trade unions and enterprise unions. Can you make the distinction clearly for us?
Yes, so you have trade unions which are national in character. Then you have those who decide to do enterprise unions. Take, for example, a union like Union of Industry and Commerce, UNICOF. It comprises of the majority of bankers. So a lot of the banks are part of the union. Some other bank could have decided, bank workers could have, look, we don't want to hell with UNICOF. We want to form a union for this particular bank alone. Okay. So that is an enterprise union. So you will see that it relates only to that bank. Whereas a union like UNICOF would deal with all other banks. So if there is an issue dealing with workers in the bank, UNICOF will be more likely to be able to deal with because they have impact in the several banks in the country, whereas you will be limited to your bank. So your influence and national outreach will be limited. So enterprise unions, though permitted by the law, will be less beneficial to you as a worker.
I remember there was a time NAGRAT, for example, was fighting I don't know if now where they stand, because they didn't have the bargaining certificate. It was the NAT, Ghana National Association of Teachers. So that is how this advice looks like. Absolutely. Instead of belonging to a small one, be in the national one, so that it benefits you. So Sadiq, is it Abubakar Sadiq, the advice to you and to many people who have your kind of situation is that joining a trade union, your friends are pressurizing you to join it. Joining it is not compulsory. However, it is very much advisable because of the benefits you will get. Remember that united, we stand. When you are divided, you fall. You are alone at the workplace. You won't get better than those who come together to negotiate better conditions of service. Abubakar Sadiq, and all of you who are in his situation, this is the advice to you. Thank you very much indeed to our lawyers, Lamtig A. Apanga, who is Managing Partner, Prestige Partners, and Charles Bardua, who is Managing Partner, Law Alert Group. And today they decided to toe the line of the Speaker of Parliament. They are both in nice traditional wear from the upper regions of Ghana, and I am in, so this is like Obroni. It's not nice. Speaker Babin said this is not good. We should stay local. All right. So as we promised you, today we are going to open the phone lines. in good time enough so that you can ask your questions about the contract of employment. What are the difficulties you have? What do you want to know before you sign a contract of employment and the rest of them? So if you have any issues that relate to the question of joining a union, like Sadiq brought in, you could also ask and you get answers. But there were two main questions that were sent to us about the issue of undue influence in the contracts of employment, and also the question of contract in restraint of trade. Let's get to know what these two are and what implications they can have for your contracts. Yes, Charles. So which one would you like to take first?
Well, either of them.
All right. Okay, go ahead.
For example, undue influence.
Yeah.
Undue influence is talking about an agreement whereby one party, is influenced by certain factors, which makes the contract somewhat unenforceable or unfair.
Okay.
Because the party was influenced by that fact or under some kind of disadvantage.
Right.
So take, for example, we talked about when we are issued with an appointment letter.
Right.
There is no job in Ghana, or it is scarce to get jobs. I mean, in negotiating that kind of agreement, you are influenced by these facts. So you are tempted to lower your standards, to accept the contract, even though you may not be happy. So, in terms of contract, simple contract, ordinary contract law, this kind of agreement may not be enforceable.
Okay.
However, in this country, the law has provided some minimum protection for employment.
Okay.
So when it comes to employment law, because these minimum protections have been provided by the law to protect the workers, knowing very well the differences in the bargaining strength, the issue of undue influence and employment law in Ghana has become a bit of reduced. And so it is not much of an issue, even though it works to the disadvantage of the worker.
Okay. Yes. What do you want to say to that? And what are the implications where, particularly, we know that normally it is the employer that will exercise that kind of influence, and it may affect the one who is coming for the job. What are the implications of that so that employers may avoid it?
Well, it depends on the nature of the undue influence.
Okay.
It may turn out that you may have been promised some terms or some benefits, but when you get into the workplace, now those promises that were made to you at the time you were coming into the employment are not being fulfilled. Now the question is, were these put in writing? If you can establish that these terms and conditions that were offered you earlier on were put in writing, you can then demand for them. Now, undue influence may be the basis to set aside the employment contract, and also be the basis to even proceed to court for compensation where you think that you have been wrongfully dealt with.
Okay.
And so, but you need to establish the nature of the undue influence.
Okay.
In order to be able to use it as your advantage in court to seek some redress.
Okay.
If you don't, then it becomes difficult for you to.
All right. So we are speaking to them generally. This is not a law class. We can't go through them one by one. If you have questions, we'll help to elaborate on it. Now, Kwesi Osei Treme, you are calling from Brekum. Let's hear you. Straight to your question or contribution.
Please,
Kwesi, go ahead.
Yeah, it's a question. May
Yes.
I ask, Senate, is it a union?
What?
Senate, is it a union?
It's not a union. Thank you for your question.
Yeah.
Emmanuel. Hello, Emmanuel. Let's hear you. Hello, Emmanuel.
Hello. Yeah, good afternoon, sir.
Yes, good afternoon. Please speak up.
Yeah, please. I also have a little problem, and I want to ask the lawyer.
Go ahead.
I was joining union on mining sector, and later we have a CA collective agreement. But what they put, the laws they put on the CA, after the company breached it, they did not follow the procedure. But the union fight. They refused to accept what happens. I resigned from work, and later I wrote 1 month notice. It's on the CA. But later the company stand on the same day accepted my resignation without follow the CA, the collective agreement for 1 month notice. And I want to ask the lawyer if they can help me on that way.
Okay, Emmanuel, thank you very much. We'll keep it there. Now, first, yes, Lamting, the Kwesi is asking, is SNIT a union? Kwesi is from Brekum.
SNIT is not a union. SNIT is not a trade union. SNIT is an intervention. It's a public service intervention brought by government. It's a body corporate established by government to provide some protection for workers at the end of your work life, so that you can have some insurance of minimum life to sustain yourself even after work.
Okay.
So that at least you can earn something to sustain yourself when you are...
Great. So it's not a union. What would you have to add to that?
Yes, clearly SNIT is not a union. But workers of SNIT join unions.
Okay.
So SNIT,
right,
as my colleague has said.
Yes. And as by its definition, a social security and national insurance trust. It's a trust. Before we go to Emmanuel's issue, let's pick Enoch in where? Is he AG? Hello, yes, Enoch.
Hello, sir.
Yes, let's hear you, Enoch.
Please, can my HR determine which bank account to present when I am employed?
Can your HR decide which bank you do what?
Which bank accounts I should present for controller when I'm employed?
So, which bank you should have business with? Is that the case?
Yes, please.
Okay, thank you. Theophilos, you are calling from Bupe. Let's hear you.
Yes, Samson. I want to find out if your employer renew your contract for the third time, what legal options are available for you, the employee? Thank you.
If your employer does what?
If your employer renews your contract for more than 3 times, what legal options are available for you as an employee?
What do you mean by release your contract?
Renew your contract.
Renews your contract 3 times. Then what?
You renew your contract for 3 good times.
3 different occasions.
Yes.
Your contract is for how long at a time?
Say 2 years. Then after 2 years, it renewed for 1 year. After 1 year, it renews again.
Okay. And your question is?
What legal options are available for you, the employee?
Now your employer doesn't want to renew it anymore. Is that the case?
I think I understand.
Okay.
He renews it, but we want to find out what legal options are available for you as an employee.
Yeah, we have an idea. We have an idea what you are driving at, but you are not explaining it. Thank you very much. We'll get to it. Samuel, let's hear you. Samuel, you are calling from Jolo. Okay, so we'll get back to Samuel. Please, let's hold on with the call so that we can deal with those that have come. Theophilus' question. His contract has been renewed a number of times. He has some idea about something. I'm sure that he's been educated about the law in this regard.
Yes, I think his complaint calls to question the legality of contract work. You know, there's a practice, an emerging practice in Ghana, where, in fact, permanent workers are being terminated and they are given contracts.
Yeah.
So at the end of the contract, they keep renewing for them. Now, this situation is one of concern because it is emerging and destroying permanent work. The law on it was discussed by the Court of Appeal in one commercial bank case, in which the court said that if the job you are doing is seasonal in nature, or it is intermittent, then contract agreements for a specific period will be legal. However, if it's a permanent job, the work that you actually do is permanent in nature. The employer, instead of giving you a permanent appointment, keeps renewing every year so as to reduce your rights and intimidate you into insisting on certain, because at the end of the 2 years or 3 years contract period, the employer is not under any obligation to renew it. That reduces your negotiation ability and strength. So the court said that that will not be in tandem with the spirit and letter of the Labor Act. So it will depend on if the worker wants to take up the matter, to take it up. I mean, I know that certain circles or certain trade unions have discussed this matter, and in the process of fighting it.
What is it that the employers try to avoid, or what is the benefit they try to gain unduly by keeping people on contract basis rather than giving them permanent employment status?
So they weaken the worker. Because if your employment is not permanent, you will always try to go to whatever the employer says, so that at the end of the contract period, you may get an extension. So it weakens you in your negotiation and provides some uncertainty in your future. So the employer, knowing this will weaken you, will give you a contract, and then will give you any terms that they wish. Because you don't.
And apart from that,
yes,
we have heard of issues, for example, like your medicals and other things. Because you are not on a permanent employee, you are not entitled when they do that to you.
No, it will depend on the terms of the agreement. If the contract provides for those things, you'll be provided. The significant thing is the permanence or otherwise of the employment. The lack of certainty of your future employment.
Right.
It's creating, adversely, thoughts and, as it were, conditions that are not favorable to the worker.
Yes, and what do you want to add to that? Doesn't the law say that if as long as we see that the nature of the work you do, like he said, it's not something that is seasonal. Yeah. So it's not there, we call you to come and do it now, and then the job is finished. So you have to go rest. The next season you come. If it's not in that nature and the work is always available, but you are simply just doing this to me, it should rather be construed as permanent rather than...
Absolutely.
Yeah.
Something, there is an issue here, the issue of termination. Every termination, particularly if it's wrongful termination or unlawful termination, comes with some compensation available to the employee.
Okay.
Now, if the contract is for a period, all the employer needs to do is wait for the period to elapse, and the contract naturally has come to an end. So he owes you no obligation to compensate you for. Okay. Now, you don't even call it lawful or unlawful termination. The contract has come to an end. But as you said earlier on, it depends on the nature of the work. For instance, take a teaching profession. It's a continuous work every academic year. But then you are called in every academic year, given one academic year contract. At the end of the academic year, it's renewed or not renewed.
So the law frowns on this?
Law frowns on it. Okay. What it means is that you can't bargain increases in salary, you can't bargain for promotion, because you should be able to move from class 1 to class 2 in your employment status. But because you come in as a contract worker, you are unable to do so.
So if you are being treated like this, you can, what can you do? What are your options?
You can seek, as it were, a protection in the court. You can also go to National Labour Commission. Okay. In fact, it is provided in the Act that when an employee works for a continuous period of 6 months and more, his employment is deemed to be permanent work.
That is right. So a couple of your questions are still here, but let me pick Philip. Philip is calling from New Ebrim. Hello, Philip. Mauli, you were also calling from Akachi. Have you lost you? Yes, Philip, let's hear you.
Please, I want to ask, if you are going on pension, and you have been paid, is it right for the company to tax you?
Is it right for what?
The company to tax you.
Okay. Tax on your pension?
Yes.
Your benefits?
Yes, sir.
Pension benefit.
But which benefit? Because your pension benefit is paid not by your employer. Yeah. It is your contribution as SNIT.
Yes, the contribution, no, we have a certain amount which the company used to. Because when we are in the, if you are in the company, they do pay some amount to you. Then they deduct to you also. So they gather the two of them, then they quit it for you for some time. As soon as you are going for the pension, then they give you.
Okay, that's a nice arrangement. Let's see what the lawyers will say. Now, Paul, you are calling from Boga. Which part of Boga are you calling from?
Boga Soin.
Boga Soin.
Yes, please.
Okay, go ahead. Let's hear you.
My question is, you've worked with a company for almost a year, and recently he has given you a contract, and the contract is stated as casual. Is it rightful, or is it the right thing to do?
Okay.
And secondly, in the contract, there was a statement of medical facility, but the company has not given out any facility to any of the workers to say, this is the facility, go there when you are sick. You have to go and pay your own bill, then they receive, then they'll look at it, whether it is valid for them to pay or not.
Okay, okay.
And thirdly,
no, it's okay. Thank you very much, Paul. Let's answer this one, then you can join us another time. We'll take a very final call. We can't take more than that. Let's take Idrisu. Idrisu, you're calling us from Tamale.
Yeah, Samson, good afternoon.
Hi, let's hear you, Idrisu. Go ahead.
Good afternoon, Samson.
Good afternoon.
I hope you are doing well.
Grace of God. Go ahead.
Thank God. Samson, I want to find out from the lawyer with this regard to NAPCO. What can we do about it?
What's that?
NAPCO.
NAPCO?
Yes.
What about NAPCO?
We've been asked to go home. The contract is ended. That was last.
Yes, but you know you signed up for a 2-year contract.
Yes.
Yes, so what do you want to do?
When it gets to October, we were asked to go. That is ended. But we're not paying 2 months.
Okay. So about the pay. Thank you.
We're asked to go back to post again.
Okay, thank you, Idrisu. So let's start from Idrisu. Yes, he's a NAPCO. They are not employees. They are, what do you call them?
Trainees.
Yes, trainees. Right.
Well, NAPCO is a special situation.
And NAPCO recruits.
Yes, recruits, trainee, or yes. NAPCO is a special situation.
Right.
There is an intervention that was brought in by government to help train some of the graduates to make them employable, because we had a gap between employable skills and what they have learned from school, and also because of the issues of unemployment. But it was for a particular period. It's for a 2-year period.
It's like an internship.
Absolutely.
To acquire experience.
Internship. So once you have exhausted that period, you're supposed to now be ready for the job market. And so you don't expect to stay on after the 2-year period. Now, I know that there was some attempt to extend it for a period. But once they extended it and the period has ended, it's over.
Right.
What you are entitled for is the payment or what you are due during the period when you're working.
What you were not paid.
What you are not
for
paid.
The period you were not paid.
Absolutely.
Okay.
That you can pursue.
Thank you. Yes, Paul, who called from Boga, is asking about the casual, employment
Yes, so
thing.
if I heard him well, he appeared to say that he was a permanent worker.
That's right.
All of a sudden, his employment was terminated and given a letter making him a casual worker.
That's right.
If that is so, I think that it is unlawful, because the employment contract is such that one party cannot unilaterally vary it. You cannot, without the consent of the other party, reduce the benefits of the worker in the employment contract.
When COVID set in, many people were doing this.
Yes, but it will be with the agreement of the worker, because the workers must also understand the situation. That is why you must have what we call good faith negotiations, where the workers get correct information as to what happens at the workplace, especially the financial statement. So if the workers see that indeed the company is suffering, it would be better to take a reduced remuneration to maintain the life of the organization than to collapse it. Now, in the case, the scenario that Paul has talked about, if that company intends, for whatever reason, to reduce the conditions of service of the worker, make them casual workers, then they must declare them redundant and pay them redundancy pay.
Okay.
Thereafter, the company can now decide that, look, I am not taking you on this new
redundancy pay will involve a lot.
Yes.
The company may spend all the money they have.
Yeah, but that will be the consequence of the decision the employer is taking without proper advice.
So you must, first of all, sort of retrench.
Retrench.
And then they on their own will decide whether they will join the new arrangement you are bringing on.
You would offer them...
By which time they would have taken home a certain lump sum. But to just terminate and change without preparing
That's wrongful.
It is unlawful.
That's wrongful. So the place to complain to is...
Of course, the National Labour Commission is always there.
All right.
The courts of law are also there.
Okay. So so you dealt with Idrisu in Tamale, and you have taken care of Paul's situation. But there was Enoch. Enoch was asking whether or not his HR can decide the bank that he must, use for his salary. Some companies, for convenience.
For convenience,
yes.
So sometimes it is an advice, but it may appear as a directive, because the processing of salaries may be easier when all of you are with particular bank.
That's right.
And perhaps the account would be credited on time. So you don't have people saying, oh, my account has been credited, mine has been credited. And also, the staff who work on salaries sometimes need to follow up with the banks to ensure that everything is done. If he has to go to 2-3 banks, multiple banks at the same time, it puts a lot of work.
But in this case, he mentioned the controller. In this case, he mentioned the controller. So could it be that this HR has some relationship with this bank and is trying to recruit customers for the bank? Because as for government, it doesn't matter which bank you save with, is it not?
No. He cannot compel him to keep to a particular bank.
Charles, what do you want to add to that?
There cannot be any such compulsion. There can be an advice, like my colleague said, so that maybe you can get your salaries faster and in good time, and to make it more convenient to the employer to pay you.
Right.
It can't be by force.
Okay, so you're still here on the law. This is your legal light, it's your health law. Well, we are dealing with the contract of employment, but you have brought in all sorts of questions, and also the question of unionization, joining a union or not joining a union. But that's okay. We are treating all your questions for you, but unfortunately, we won't be able to pick any more questions. Emmanuel had said that they had a union, and there has been some problem. The union is trying to resolve with the employer, and the employer is not sort of resolving the issue. So he was sort of lost. What should be done?
Good. So what can be done is this. The union and the employer, if I heard him, have signed a collective agreement. He alleges that the collective agreement has been violated by the employer. Now, if that is so, that becomes a breach of agreement, a breach of contract, for which either the union or he as a beneficiary of the collective agreement must seek enforcement in the National Labour Commission, or you can always go to court to have it enforced. So there are avenues. It's not as if because the employer does not accede to your request to have the matter resolved at the workplace, you are hopeless. You are not hopeless. You can always proceed to adjudicatory bodies.
Thank you very much. Is there anything you would like to say to that?
Well, that's it.
All right. Thank you very much. A couple of questions. There are two more that have been sent by social media. And this is from Awal Mahamaba Mohammed. He says, I'm hearing this for the first time. If I may ask further, do this cover teachers in the country? Okay, so when you read the Constitution and spoke about holidays and leisure and the rest of them, he's asking whether teachers too are entitled.
Absolutely.
Okay. Why? Are you teaching at a place where public holidays don't cover you? Then there's a Simple Shan. He says, hey, my company has been in existence from 2014 till now, but don't have any union. I want to know if it is legal.
Well, it is not illegal for there not to be a union at the workplace.
Okay.
It is illegal if the workers try to form a union and the management refuses.
All right.
That makes it illegal.
Okay.
But if nobody at the workplace, any of the workers decide that let's form a union, it cannot just be illegal because there is no union at the company.
All right.
And the law says any two people at a particular workplace can form or join a trade.
Just two.
So what he needs is to get his colleague.
All right.
Come on, let's start the union.
Okay.
And it's not the employer's duty to start a union.
All right.
The company has no obligation to set up a union for you.
Right.
It is within your right to exercise that.
Thank you very much. I've seen more questions coming in. Evelyn Ayenini is my wife. She says that your guys are great. And you know she's a lawyer. Is that your mates? Okay, right. Okay, okay. Thank you very much for watching and being part of our program. Lamtig A. Apara is Managing Partner, Prestige Partners. Charles Badria is Managing Partner, Law Alert Group, and is former Executive Secretary of the National Labour Commission. So no surprise, the comments that you are making about the way they are handling the law, the labor law, as if they sleep and drink it. All right, thank you all so very much, and we can't thank you enough. Thank you very much. I was going to talk about something, but it's okay. We'll keep it a secret. Have a good afternoon. I'm Samson Ladia Yenini. God willing, next week we come your way with the law again, and this is your Legal Light. It's your help law. Now, the issues we have been dealing with were you sending them to us. You can send some more to us at samson.ladi@myjoyonline.com. That's the email, samson.ladi@myjoyonline.com. Be very brief about your issue, and then we'll get the lawyers to come into the studio to answer. And we know that by solving your question, they will be solving other people's questions as well. Thank you very much. Have a good afternoon.